Welcome to Solving Citizen Legal Encounters. All right, today we're going to be dealing with a follow-up on a trained sovereign citizen that I covered maybe a couple of months ago. So this trained sovereign citizen is working in partnership with another trained sovereign citizen. Those two together have a trainer that's been showing them how to do things with the script. So this video is going to have the follow-up hearing from the latest court case. But for those who may not have seen it, I already provided commentary on the first case. But what I'm going to do different in this video, I'm going to do his update. Also, the other sovereign citizen who's been being trained with him, I'm going to add her at the end of the video so that you can kind of see and compare how they're doing their scripts, because it's totally different from anybody else that run these sovereign citizen scripts. I'm doing it here because that video was embedded in the live stream and the regular viewers probably didn't even see it. So we're going to go in and check this out. Let's go.
This is State of Kansas versus Quentin Lawrence Hite. It's case number 2025 TR 1215. Quentin Hite appears apparently on his own Zoom. Jaron Regier appears on behalf of the State of Kansas and the Butler County Attorney's Office. For Hite, court has an information before it which alleges in count one a charge of interference with law enforcement, a Class A non-person misdemeanor punishable by up to $2,500 fine and up to 1 year in the county jail or both. In count two, failure to register a vehicle, an unclassified non-person misdemeanor punishable by up to 30 days in the county jail and up to a $500 fine or both. What are your intentions regarding a plea here this afternoon, Mr. Hite?
Good afternoon. I do not intend to plead.
Why is that, Mr. Hite?
I have a few clerical things I'd like to clear up. Did you personally read the case filing for BU-2025-CR-000261 in its entirety?
No.
Do you believe that the filing document is true, complete, and correct?
I'm not sure why I'm answering your questions, Mr. Hite. We're here on a first appearance on a criminal case.
I am trying to clear up to make sure that the charging documents are true and correct before proceeding.
One, I never seen a sovereign citizen dressed like that. Two, he's not mentioning all caps name, straw man, none of it.
I see nothing openly defective about the charging document.
Okay,
Let's move on. If you don't wish to enter a plea, the court will be entering a plea of not guilty on your behalf, Mr. Hite. And we'll be establishing another court date.
Your Honor, that would not be my preference. I would like to have...
Well, I don't care if it's your preference or not.
That's how you shut him down.
Thank you. I would like to have a probable cause hearing before a plea.
You're not entitled to a probable cause hearing. This is a misdemeanor case rather than a felony case, and you're not in custody.
Okay, I have challenges that I would like to raise on the record formally for both the case filing and the field case report from the arresting officer.
Let me ask you, do you believe that you have the financial resources to hire a lawyer to represent you in this case?
I will not be hiring a lawyer. Thank you for asking.
So you're going to represent yourself in this case, is that correct?
I will be presenting myself. That is correct, yes.
You do understand that if you can't afford a lawyer, the court will consider appointing you one.
I do comprehend this. Thank you.
But you reject either retained or appointed counsel, and you're going to represent yourself in this case, correct?
I will be presenting myself.
Very well.
Thank you.
There was an appearance bond posted in this case. Apparently, it was a cash bond in the amount of $2,000. It secured the defendant's appearance. The court has approved that bond and will maintain Quentin Hite under it pending further proceedings in this case, which I will set.
Before that, I would like to request your lawful determination that this court has jurisdiction over this matter, as I cannot proceed until the field case report and the case filing are both verified complaints and true and correct.
I don't know where you're getting all this.
Right there on his computer screen, Judge.
According to the state's charging document, I'll advise you, Mr. Hite, that it did take place somewhere in Butler County, Kansas.
Okay, thank you for that.
I do believe it has jurisdiction.
I do have a copy of a field case report and a case filing that I received from the Butler County Attorney's Office as well as the Butler County Sheriff's Office, and I have found inconsistencies in both of the documents that I'm trying to raise here formally with you that I cannot make a plea until they have been resolved.
All right. So I've entered a not guilty plea on your behalf.
I would like to please the court that this would be not on my behalf and under threat and duress, and only under the matter that you have moved on my behalf. I have not entered a plea.
All right.
Additionally, I'd like to let the record show that due to a lack of corpus delicti via verified complaint, jurisdictional defects, and the lack of essential elements to bring a formal complaint and charges against me, I must move for dismissal immediately based on the plaintiff's failure to present all the required elements. That is in regards to the case filing. Judge, I would also like to ask, will you be reviewing the case filing and field case report in their entirety to ensure that my due process rights are not violated before the arraignment hearing begins?
Court's going to assign the case to this division. I'm going to set a court date for Monday, August 25.
And what is the purpose of that court date, may I ask?
For further proceedings in the case, Mr. Hite. It'll
Okay.
be your first appearance with following today's date. I'm going to set
Would
the
you
hearing
repeat that again?
time at 3:00 p.m. You may
My
appear
apologies.
by Zoom.
Is there an
3
in-person?
o'clock Monday, August 25 for further proceedings in this case before this court.
Thank you. And may I ask, is there an option for an in-person appearance?
Not for that court appearance.
Okay.
We'll conduct the next appearance by Zoom.
Okay. Is there an opportunity to be in person for any proceedings?
Yes.
Okay. And
But-
which proceedings would those be?
But what we've established today is the next one will be by Zoom. Now,
Okay.
if you don't want to appear remotely, you can come to the Butler County Judicial Center and you can participate from that location. You'll be participating by Zoom, but you can participate from the Judicial Center. So make
Okay.
sure that you have the resources available to you to fully participate in the next hearing. So Monday, August 25, 3:00, he's going to represent himself. And the court has approved and maintained him under his previously established bond of $2,000 cash.
May I also ask what
Okay,
judge
just a
and what
minute, I'm going
court?
to ask the prosecutor. Mr. Regier, is there anything else that we need to address regarding Quentin Hite at this time?
Not on this particular matter, Your Honor, although in per my duty of candor as an officer of the court, I would tell the court that there does appear to be another case involving this same defendant, where it would appear that an appearance bond has been executed for at the end of next month. I'm not sure, given the court's orders today, if the court wishes to address that matter at this time for the purposes of the judicial economy.
No. If he has multiple cases, that's the implication of having multiple cases, that he may have multiple court dates.
Remember what he said about the court dates. That's going to come up again.
Very good. Your
So
Honor.
let's go ahead and cite for Mr. Hite, just in case he doesn't have it written down on his calendar somewhere. What is the next scheduled appearance in this other case?
Your Honor, the state's information is that in Butler County 25 TR 1215, there appears to be a bond, specifically a cash bond in the amount of $1,000 for an appearance date on July 30th, 2025 at 9 a.m.
All right. I'll advise the defendant that he does have a separate appearance requirement in a different case for July 30th at 9:00 a.m. I trust that would be in Zoom court with Judge Webster on that date, Mr. Regier?
That would be the state's presumption, Your Honor.
Okay, and then of course you've still got your Zoom appearance requirement in this court on Monday, August 25 at 3:00, Mr. Hite. I
Thank you
think
for
that concludes our business on
I have
your
one-
case
one
at this
further
time.
One further question, please. For this matter, the new hearing that you have just set, who is the judge and the court presiding?
The new one that I just said, you mean in this case that was before the court today?
Correct.
This judge is hearing the
Okay.
case.
Thank you for clarifying.
And if there's nothing further, The Quentin Height matter will be in recess at this time, and we'll move on to another matter.
Thank you for your time.
As you see, the judge wasn't playing around with him in this hearing. Now, the reason why you see the female at the end, because originally in the video, I added her part and his part when both of their scripts sounded pretty much the same. So now we're going to go into her hearing since you just heard his hearing, and you can listen to do the comparison between the two. And then after that hearing, we'll go into the most current hearing because there is a slight change in the new hearing. Let's go.
Next case, State of Kansas versus Sydney Taylor Leslie, 25 CR 250. Good
Yes, Your Honor.
afternoon, Miss Leslie. Miss Leslie, you're charged by way of information on or about May 21, 2025 in Butler County, Kansas, with interference with law enforcement, a Class A non-person misdemeanor. Count 2, same date and location, no proof of insurance, a Class B non-person misdemeanor. Same date and location. Count 3, no driver's license in possession, an unclassified non-person misdemeanor. Though, then count 4, same date and location, failure to register vehicle, an unclassified non-person misdemeanor. And Miss Leslie, do you understand the charges pending against you?
I comprehend the alleged charges against me.
We normally hear, I don't understand the charges.
Thank you, Miss Leslie. Miss Leslie, you do have the right to counsel if you cannot afford an
Excuse me.
attorney. Pardon me?
Excuse me, I was going to say that I comprehend the certain statutory allegations that have been made against me, but I cannot and do not admit to understanding or accepting the jurisdiction of this court over my person or the subject matter absent proof of corpus delicti and a verified complainant from an injured party. To do so would constitute a waiver of fundamental rights, which I explicitly refuse to waive pursuant to KSA subsection 60-212 and the doctrine of special appearance recognized in Kansas jurisprudence.
Now, the script that we're used to hearing always wants to argue the charges and jurisdiction. Their script, they're not even worried about the charges. They're going straight in for the jurisdiction.
You do have the right to counsel if you cannot afford an attorney. One would be appointed to represent you. And Miss Leslie, are you currently employed?
For the record, Your Honor, just to start from the beginning, I, Sydney Taylor Leslie, appearing specially and not generally in propria persona, sui juris, as a living woman and not as a legal fiction or corporate entity. I reserve all rights without prejudice pursuant to KSA subsection 84-1-308 and UCC 1-308. Let the record reflect that my appearance today is under explicit protest and duress and solely for the purpose of challenging jurisdiction and preserving my unalienable rights as secured by the Constitution for the United States of America and the Constitution of the State of Kansas. And Your Honor, before these proceedings advance further, I must respectfully challenge this court's jurisdiction in toto and move for immediate dismissal of all charges. I hereby invoke the burden-shifting doctrine established in State v. Shepard in 2009 and State v. Seams in 2004, which places the affirmative burden upon the prosecution to establish by sworn non-hearsay allegations within the four corners of a valid charging instrument that every element of the alleged offense and my commission thereof has been properly established. The threshold matter of jurisdiction must be adjudicated prior to any other proceedings. As articulated in Ex parte Young in 1908 and recognized by the Kansas Supreme Court, jurisdiction is the fundamental prerequisite to all jurisdictional proceedings. The legal maxim ex injuria just non autora, law does not arise from injustice, applies to these proceedings in their entirety.
If you know what all of that meant, put it in the comments.
Okay, and the court finds that Miss Leslie is appearing as a sovereign citizen before the court, and the court once again.
I object to any of that derogatory. It's very biased. I move for immediate dismissal on those grounds.
As mentioned in other videos, people that read that sovereign citizen script hates to be called sovereign citizens.
And
Court
disqualification.
Court overrules the motion for dismissal of the case.
On
Court overrules dismissal
this is
of the
prejudice.
case.
And
The court will find that Miss Leslie, that the court does find it has jurisdiction to proceed. And subsequently, the court
I
sets your next
object. You
appearance
called me
date.
a sovereign citizen. I object. You called me a sovereign citizen.
Yes, ma'am.
That is prejudice and bias. And
No
it
prejudice or
demands
bias
for
is asserted
immediate
as to
dismissal of my
yourself.
case.
However, the court, as opposed to trying to write down docket notes to that effect, is just recognizing what you are advising the court, that the court has no jurisdiction over you, and based on your statement made to the court. Subsequently, the court does find you've posted a $3,000 cash bond. $3,000 cash bond has been made. Court does accept the same. And the court does schedule this matter next before Judge Webster on Monday, August 11, 2025 at 9 a.m. Monday, August 11, 2025, 9 a.m. before Judge Webster. Once again, Monday, August 11, 2025, 9 a.m. before Judge Webster. You do need to participate by Zoom process at that point. Subsequently, the court finds that Miss Leslie has not requested court-appointed counsel. Court does not appoint counsel at this point. The court does find that she has posted bond in the amount of $3,000 cash, $3,000 cash bond, and the court has scheduled her next appearance date before Judge Webster on Monday, August 11, 2025 at 9 a.m. Any other matters to come before the court, Mr. Sweeney
No, Your Honor.
and Miss Leslie?
Your Honor, my jurisdictional challenge is predicated upon multiple independent grounds, each sufficient to warrant dismissal. First, I challenge personal jurisdiction pursuant to Kansas Rule of Civil Procedure. I appear specially, not generally, and have not consented to this court's jurisdiction. The record before this court is devoid of evidence establishing proper jurisdiction over my person as a living woman rather than a legal fiction or corporate entity, as distinguished in Hale v. Hinkle in 1906, and recognizing Kansas jurisprudence. Second, I challenge subject matter jurisdiction pursuant to Kansas Rule of Civil Procedure 60-212, B1. No verified complainant from any injured party has been filed as required by KSA subsection 22-2301 in Butler County Local Rule 3.1. The perpetrated charges arise from actions of agents of the state acting under a color of law, not from a legitimate controversy between adversarial parties withstanding as required by Article 3 jurisprudential principles adopted by Kansas courts in State ex rel. Morrison versus Celebius. Third, I challenge territorial jurisdiction. The alleged incident occurred after I had ceased operating my conveyance and was exercising my unalienable right to travel, placing it outside the territorial jurisdiction of traffic enforcement under KSA subsection 8-244, which by its plain language applies only to licensees who have voluntarily entered the regulatory framework. Fourth, the prosecution cannot establish the corpus delicti of the alleged offenses. As held by the Kansas Supreme Court in State v. Stern in 2015, the corpus delicti rule serves as a safeguard against convictions based on false confessions or statements. One cannot interfere with a peace officer absent of officer's lawful execution of duties. Where the initial detention was unlawful, as it was here due to lack of probable cause, there can be no derivative crime or of interference. Fifth, the refusal to provide identification is not a crime in Kansas, absent specific statutory circumstances not present here today. This is in support by Brown versus Texas in 1979. The Supreme Court held that detaining a person solely to obtain identification It violates the Fourth Amendment absent reasonable suspicion of criminal activity. The principle has been recognized and applied by Kansas courts. In one moment, please, while I gather another statement.
One thing I've noticed, they will read those scripts during a hearing, but they never turn those scripts in as part of their motion. And I'm sure it's probably in the manual. Do not turn these scripts into the court.
Okay, and another thing is, and this is, may it please the court, for the record, I must now enter an oral objection and motion for disqualification of the presiding judicial officer pursuant to Kansas Rule 2.11 of the Code of Judicial Conduct, as well as controlling principles under the Due Process Clause of the 14th Amendment. During a prior proceeding, specifically, this court referred to me by the term sovereign citizen, a pejorative classification which carries with its government manufactured implications of extremism, frivolous, and legal irrelevance. This label, unprovoked and unsupported by any factual predicate, constitutes a stigmatizing judicial characterization that violates my right to a neutral and detached tribunal. The use of that term demonstrates either a prejudiced bias or a judicial predeposition toward delegating the substance of my legal posture. As the Kansas Supreme Court has held, even the appearance of partially mandates recusal, and here the record reflects actual prejudice in open court.
They have a sovereign citizen script for being called a sovereign citizen.
Therefore, I respectfully move this honorable court to dismiss all charges with prejudice for lack of jurisdiction, issue a finding that the prosecution has failed to meet its burden of establishing jurisdiction, order the immediate return of all my property seized, including the 251 USD, confiscated and converted to a reloadable Visa card without my consent, order the expungement and permanent sealing of every associated record pursuant to KSA subsection 22-2410, award compensation for the full measure of damages sustained, including costs for my automobile window repair, bail costs, and compensation for unlawful detention and deprivation of liberty, grant such and other and further relief as this court deems just and proper. The breaking of my automobile window without warrant or probable cause of a search and confiscation of my currency constitutes violations of clearly established rights for which the law provides remedies pursuant to the maxim ubi jus ibi ridium, where there is a right, there is a remedy. I reserve all rights without prejudice, waive none, and maintain my special appearance for the sole purpose of challenging jurisdiction and preserving my alienable rights as secured by the Constitution for the United States of America and the Constitution of the State of Kansas. And thank you for hearing me. I do appreciate you, Your Honor, and thank you for your time.
And once again, matter is set before Judge Webster on Monday, August 11, 2025, 9 a.m. by Zoom. There being nothing further to come before the court is in recess, and have a good day, Miss Leslie.
Thank you, Your Honor.
Hearing that script made me tired, and I'm sure it did the same for you. But Judge Hart let her talk and get everything on the record. But as you see, they have a way of reading the script and they're prepared for everything. And trust me, they pay for those scripts. And that sovereign citizen script for being called a sovereign citizen, I'm sure that was a lot of money for that one. But anyway, we're going into the next hearing where we have the follow-up for the first hearing that I showed you. And we're going to see how this goes because there's going to be a slight twist in this one. Let's go.
Will now be on the record in, did we not do height? I thought we did.
We have not yet, Your Honor.
Oh, he's the one that didn't have his name on the screen. We're on the record in 2025 TR 1215, State of Kansas versus Quentin Lawrence Height. Brett Sweeney for the state. The defendant appears in person and per se. Mr. Height, count one, you're charged with driving without your license and possession when demanded, an unclassified misdemeanor. a sentence up to 30 days and $500 maximum fines. And count 2, driving without registration or tag, an unclassified misdemeanor, up to 2,500 in fines and 30 days to 6 months. Do you want to, well, how do you want to proceed, sir?
Good morning, Your Honor. My name is Quentin Lawrence Height, the accused in this matter. I'd like to briefly state for the record that I have made good faith efforts to meet with the prosecution prior to today's proceedings. I called the Butler County Attorney's Office twice and had in-person meeting times set up to discuss a dismissal agreement with the intention to obtain and present a valid Kansas driver's license, insurance, and registration on the car involved. Unfortunately, I was rescheduled on both occasions. The most recent meeting was scheduled for yesterday afternoon, but I was informed that Jared Regier had jury duty this week. At 7:55 a.m. this morning, I sent an email proposing a dismissal agreement. I also called the office at 8:19 a.m. to speak with Mr. Jared and his team, but unfortunately, Jared and both Brett Sweeney were unavailable. With that said, I am not sure if Mr. Sweeney was made aware of my meeting attempts, emails, or phone calls this morning by the receptionist in the county attorney's office this morning. Additionally, I do have a meeting set in person for August 7th at 3 p.m. for the discussion of the same matter. Given these circumstances, I request a continuance. I believe with a short amount of additional time, we may be able to resolve this matter efficiently without burdening the court. I'm also available to meet with the prosecution in person over the phone after court today or before 1 p.m. tomorrow. I'm also available to register my car on the same timeline to satisfy the diversion agreement.
Question: does this sound like he's going to register his vehicle only if they grant him the dismissal, and that's why he's trying to make the appointment to see if he registers the car, will they let it go? Let me know in the comments.
I respectfully ask the court for a brief continuance so that I may pursue this resolution opportunity directly with the county attorney's office. Thank you, Your Honor, and I yield.
All right, so are you waiving your right to counsel then and representing yourself?
I am presenting myself today.
And you understand that you can hire any attorney, and if you cannot afford to hire an attorney, you can apply for court appointed and see if you qualify?
I do comprehend, yes.
Okay, would you wish to proceed on your own behalf? Is anyone making you give up your right to an attorney?
No one.
All right, well, I'm showing that you have knowingly and voluntarily waived your right to counsel so you can represent yourself. With that, please, in the journal entry and docket notes. Next, have you looked online at the diversion program to see if you are interested in that?
I have not had an opportunity to do so. As I had stated, I was hoping to discuss the terms in person with Mr. Regier, or hopefully this morning, Mr. Sweeney, but they were both unavailable. So at this time, I have not reviewed the terms, no.
Looks like you have some pending cases in about at least 2 other counties. Does that sound right?
I would like to say that those matters are separate. I don't know if that is true or correct.
Well, 2 of them are in Butler County. It looks like one in Sedgwick. Let me see when the court date is so we can maybe put them together.
And Your Honor, I was going to mention that this case has actually already been set on Chief Judge Ricky's docket for another hearing, August 25th at 3 p.m.
May I ask, Destiny, are you talking in regards to the current matter that we were discussing today, the 1215?
Yes, it's regarding this case. It's going to be set with the other case as well, though.
Interesting.
Right.
Okay.
Okay, so is Judge Ricky reassigning these 2 cases to himself?
He is, Your Honor.
Okay. Is there a felony case, Mr. Height?
I'm sorry, say again, please.
Well, I was just curious why Judge Ricky would snag 2 misdemeanors out of the group here. Do you have a felony case pending with Judge Ricky?
Not that I'm aware of, and as of my first hearing on the other aforementioned matter, he said he would not be lumping these 2 together. So this is of news to me. I was not made aware of this. And I also did state that my preference would be to have them separate, and he agreed as such. So this is interesting to me.
Mr. Sweeney, any information you might be able to have or like to shed on this?
Just kind of hearsay, Your Honor. Mr. Regier prepping me for today's docket, did talk to me about this case and said that maybe he had a meeting coming up with the defendant, but he did mention that Judge Rickey rather took one of the cases, but my understanding in speaking with Mr. Regier is that the other case was to remain in front of your honor. So all of them are misdemeanors, of course, including this one. But my understanding is that he was retaining one of the misdemeanors, but this traffic case was to remain down here. I could be incorrect, but that's what I understood in speaking with him.
And I believe that was what was previously stated. I do have a note as well on this case in the 25 TR 1215 from Judge Rickey's assistant, stating that it's to be moved and set for August 25th at 3 p.m.
Okay.
All right, Mr. Height, I'm not sure what Judge Rickey has in mind, but I trust he does beyond any doubt. So we're going to move this case to Judge Rickey's docket, August 25th at 2:30.
Okay.
And license and registration. No clue, but I have plenty of cases to object. I'm grateful for any help. Let's see.
I would like to note on the record that it is my preference to keep these separate. Just wanted to make that heard.
That will be noted. Please note that on the record. An unclassified, two unclassified, you don't have to make bond in that case. So I'm going to order that you reappear at the date and time given before Judge Rickey. Did he say whether he wanted that by Zoom or in person?
My request would be to be in person. And also I did want to state one more further thing for the record that the judge had during, like I had mentioned earlier, but wanted to make sure the record reflected that he was not planning to put them together. So just making that available. Thank you.
Okay. All right. Well, you may go, sir. Choose from these proceedings. Just make sure you reappear at the date and time given.
Okay. And one more time for me, please. The date.
August 25th at 2:30. Didn't you say, Destiny?
I show at 3 p.m., Your Honor, but
Okay.
August 25th nonetheless.
August 25th, 3 p.m. And did he say again in person, or did he specify Zoom or in person?
I show that the other case is set by Zoom, so I would presume that both will be set by Zoom, Your Honor.
Okay. You might call back close to the date and confirm that that's right, sir.
Okay.
If you want a court-appointed attorney, you need to turn in an application for one. Do you want an attorney?
I do not.
Okay. All right. You may go, sir.
Thank you for your time.
Thank you for yours.
All right, as you see, he's still maintaining his sovereignty and trying to keep things up with the script. But the funny thing to me, what I got out of it is that he'll register the vehicle if he can get the dismissal. I could be thinking the wrong way on that. So you can let me know what you think. That's why I asked that question previously, and I'm sure you'll all let me know. If you enjoyed the video, give it a thumbs up. See you around on the next one. Thank you for your time.
Welcome, misunderstood citizens, to the Lords of Legal Fiction, where the law is whatever we scribble on a napkin at 3 a.m. after 6 Red Bulls. Are you tired of government tyranny like stop signs, taxes, and reality? Do you believe the secret to freedom is screaming, "I do not consent," at a confused police officer? Then boy, do we have the legally binding imaginary loopholes for you. We'd like to thank our sponsor, Hutch, at Sovereign Citizen Encounters.
I'm Hutch, and I approve this message.
After graduating our masterclass, cops will be on their knees begging for your forgiveness. You learn how to deliver your rightful message with conviction and power. Never calmly say,
"I'm not driving, I'm traveling."
No, no, no. Scream it like you mean it. Enroll in our Lords of Legal Fiction masterclass to learn how to turn every traffic stop into a constitutional crisis and every courtroom into your personal improv show. Why pay a lawyer when you can just cite maritime law and accuse the judge of being a hologram? On sale now is our Sucker Bundle. You get 1 US DOT license plate, one attractive and sturdy license plate holder, one legal only to you passport, and these impressive sheets of constitutional law that you can give to your rights-busting cop. Act now, and you can be impervious to the law and courts. You can even tear the tags off mattresses without the threat of punishment. Seriously, don't let this once-in-a-lifetime opportunity slip away. Offer not valid in 48 states. Some assembly required. Number FDIC. Batteries not included. May cause nausea and headaches. Silverware is addictive. If you need help, call Jail Me Now at 1-800-555-1212.